Thank you, everybody, for joining us today for this webinar entitled Wills, Trust, and Estates 101. My name is Krista. I am the co-chair of the Survivorship and Palliative Care Task Force, along with Carlin, and we are really grateful to Ella for putting this together. She's the project manager of the Colorado Cancer Coalition, and her efforts are what makes this possible. So this webinar is being recorded and will be posted on the Coalition's YouTube page. We are very grateful for Andrea, who's taking care of the translation piece. It's my honor to introduce David Strasberg. He is providing this webinar in kind to us. He is a wills, trust, and estates lawyer who has founded the law firm Wills Simplified. So David, it is all yours.
Excellent. Thank you. Can everybody hear me? Good. Thanks, Ella. So I appreciate the introduction, and I appreciate having the opportunity to speak with all of you today. I have a presentation, but before I get to that, I wanted to kind of introduce myself and a little bit about my practice and what brought me to offering this presentation here today. So I have my own, small estate planning law firm. It's a staff of 3. I've been estate planning, so putting together wills, trusts, powers of attorney, healthcare directives, all of those types of things for clients all around Colorado for about a decade. And really my goal with the practice that I have is to try to make estate planning as accessible as possible for individuals. Estate planning is something that is not intuitive. It can be really confusing. And oftentimes what happens is a lot of what you prepare through an estate plan doesn't really go live or go into effect unless you're either incapacitated or you've passed away. So you really want to make sure that you're taking the time to be thoughtful and intentional with what it is that you're trying to do and work with somebody that has an understanding of kind of what your wishes are. As I've been growing my practice and as I've been getting more involved with different Colorado groups and communities, something that really informed my decision and my approach to estate planning in general had to do with the fact that I lost my mother when I was 8 years old. She passed away from cancer, and that's what has kind of led to my connection with the Colorado Cancer Coalition. It's something that's really important to me, so I've been involved, from that end of being a family member and being a child that had experienced this. And really, it's like I said, it's informed a lot of what my practice is. So I want to give a presentation, kind of walk you through, some basics about estate planning, about wills and trusts. If we have some time, I'd love to answer questions that you guys have, as well. And I'll also put up my scheduling link in case anybody wants to reach out to me through the coalition. If anybody wants to reach out to ask me some questions about your own planning, or maybe you've already done your planning and you could use some clarification on something, I'm here to be able to assist. Okay, hopefully you'd consider me a resource for that. So I'm going to go ahead and get started by sharing a presentation here. And like I said, my name is Dave Strasberg. My practice is Wills Simplified, and I wouldn't be an attorney if right off the bat I wasn't saying really that every situation's different, that this is intended for informational purposes. If you want to go over your specific circumstances, like I said, you can reach out to me. You can reach out to another estate planning attorney. And like I said, happy to be able to answer whatever questions I possibly can. So I like to start off with this idea, and this is a picture of my wife, Elisa, and our eldest daughter, Ellie. I've got 3 kids, Ellie, Mason, and Madison, ages 10, 8, and 3. What is estate planning? And estate planning is really about 3 different types of things that we're trying to consider. We want to think about who's going to be in charge for us in the event that we're unable to make decisions for ourselves. And that has to do with either, like I said, incapacitation, or if you've passed away, who's making decisions for you. And then you also want to be thinking about, where do we want everything to go? You know, your assets, your family heirlooms, your home, your retirement accounts, you know, all of those meaningful things that you've spent your life accumulating. Where do you want it to go to? And perhaps most importantly, but often overlooked, is, how do we want it to get there? And that's going to be a big focus of what this presentation is, because people call me all the time to say, well, my estate is really simple. It's just my spouse and I and our children, and we just want to leave everything to each other and then everything to our kids. And that is pretty simple, and it's pretty common as far as what people want to be able to do. What then becomes a challenge and an opportunity is, how do you want it to get there? Because the way that assets are transferred, there's lots of different ways, and there's lots of implications based upon what it is that you select. Really, what we're trying to be able to do with estate planning as well, if we're taking a strategic view, is we're trying to avoid probate or mitigate probate as much as possible. I'm not sure if anybody has ever had to go through probate on behalf of somebody else or has any familiarity with it. I want to say that probate is not impossible, but it is avoidable. And really, what is probate? It's a court supervised process by which your assets get distributed. So if there's something that you have and it's in your name, you own that, and you pass away, and there's not a plan in place or beneficiary designations, oftentimes the assets become frozen. And probate is the process where they get unfrozen. It's a public process. That's how we often know about celebrities' wills and things that they had had, or fights that go on. Probate can be costly. You know, there's estimates that, you know, probate can cost 3 to 5% of your total assets on average, you know, in this country. So if you have a home and really that's what your assets are, and it's a $500,000 home, 3% of that is about $15,000. And there's ways to avoid that for your family, of having to be able to pay that. Probate can also take a long time. There's minimums in Colorado, as well as any jurisdiction, for how long it takes. In Colorado, you're looking about 6 to 12 months if you have a will, and even longer than that if you don't. And if things are uncontested or unclear, it can take years. Probate is also all about paying back creditors first. The court really makes sure that anything that you owed when you passed away is handled before anything is distributed. That's part about what takes it a long time. So, as I said, estate planning is about trying to mitigate probate as much as you can, or avoid it. And as an example, to try to think about how things operate when you're talking about an asset like your home, there's kind of a few different strategies that you could employ. There's one strategy that's, I didn't do anything. You know, how hard could this be? It's my house. I want to leave it to my family. If I pass away, then they'll get it. I'm not going to have a will. I'm not going to have a trust. I'm not going to have anything. That's not a good strategy, because it goes into probate and things take a really long time, and it becomes extremely expensive to have to maneuver that process potentially. Okay. You wouldn't be on this call and attracted to wanting to watch this presentation if your strategy was, I'm not going to do anything. Okay. You also have the other option of owning your home. And again, we're only talking about a house. We're not talking about all the other kinds of assets that you could have. You could own your home in what's known as a joint tenancy. And a lot of you that are married may already have that set up, and it's on the deed to your home. And that means that you and your spouse both own the property. And if somebody passes away, it automatically just transfers to that other individual. Doesn't mean that there's still not paperwork that needs to be done. Okay. So if you ever run into those types of situation, estate planners can assist with that as well. If somebody passes away, you still have to do some work with the county, but for the most part, it makes things easier to transfer. What makes it a little bit more difficult is if you don't own it jointly, okay? And a lot of married couples think that they do, and then they find out that they don't. So you'll want to review that. Or if you're not married, or if you were married and both of you pass away and you're trying to leave it to your children, okay? That becomes challenging as well. The next strategy is you put together a will. And when you work with a estate planner, such as myself, or maybe somebody else as well, you're trying to prepare a will that will mitigate probate. And I want to kind of pause for a second to clear up a common misconception because I get several types of calls all the time with lots of common questions that people ask that are often misconceptions. And people will say, I need to set up a will so that my family can bypass probate. That's not a thing. A will is for probate. A will is a set of instructions that you're providing the court to try to make things faster or easier. So the quality of your will really makes a big difference. So if you're thinking about the DIY options that are the bare bones, they may not be addressing types of things like, does my family have to post bond for probate to occur? Are we waiving hearings that the court is going to make my family have to go through at all? So you can have the strategy of setting up a will, and really what you're trying to do there is mitigate that probate process. I then have Will Plus, which is kind of the idea of what I do for a lot of clients, where I can turn your home into an asset that is like a retirement account or life insurance. So it adds onto it a beneficiary designation so the house can transfer. There are some limitations to that. So you'd want to talk to somebody about whether that's the right option for you and your family, but it can be something that can be very useful in minimizing probate. And then you have the option that's a trust. And people are often think, again, a common misconception is that a trust is for individuals that are extremely wealthy, okay, or that you're trying to protect lots of different types of assets. That's not necessarily the case. So I want to then continue with kind of explaining what's the difference in from a strategic standpoint between a will and a trust. So, like I said, the two primary strategies for estate planning are going to either be will based or they're going to be trust based. And future slides I'll go over specifically what a trust looks like, but just as kind of a way to contextualize it or help with conceptualize at the same exact time, a will is something that's guaranteed for probate. Like I said, people often say, I need a will so my family can bypass probate. That's not a thing. Okay. That is a huge wake up call to a lot of family members because they'll call me because a family member had passed away and they said, well, we have their will, so there shouldn't be any probate. That's not true. Wills are for probate. A trust, on the other hand, bypasses it completely. A will is for death only. So oftentimes, if somebody's incapacitated and you're trying to be able to access their bank accounts on their behalf, they'll say, well, I'm the executor of their will, so I should be able to have access. Not the case. A will is only for if you pass away. That's it. A trust, on the other hand, is something that you're setting up that handles incapacitation. So it's for your life and if you were to pass away too. A will is something that's public, so it's a public record. Anybody can access it at all. Trust is something that's completely private. You only have to share it with yourself and your family. Wills don't really generally offer any type of asset protection, whereas you can set up a trust to leave an inheritance to individuals that protects them against divorce or lawsuit or creditor or things like that. You can set it up in a way that if you have minor children, that it's taken care of for them until they get older, or minor grandchildren. If you have family that has special needs and is receiving government assistance, oftentimes that you can be disqualified from receiving that if you were to receive an inheritance, whereas a trust can be structured to ensure that the individual can continue to receive those benefits and receive that inheritance at the same time. As I mentioned before, because a will is only for death, there's no incapacitation planning, whereas a trust does look into incapacitation as well significantly. With a will, things can take 6 months to 2 years to officially transfer, whereas with a trust, other than some light, paperwork, the assets can transfer right away. You can move them right away. And trusts can also be structured in a way to help mitigate taxes and different types of government fees, obviously, because probate's a government process. So you've heard me talk a lot about a trust. What is a trust to begin with, anyway? A trust is it's a container. Okay, it's something that holds on to the assets that you have. And the way that I like to almost explain this is a trust is like a glass of ice water. And I kind of came up with this analogy or metaphor or simile. I can't remember which comparative uh, structure, it is, but because I do a lot of meetings with clients in their home. Okay. And when I go to their home, they'll often offer me something to drink. And most commonly, I would say a glass of ice water. And I started thinking that it's a lot like a trust. So the trust is something that you set up that's a container like that glass. And the assets that you have, you coordinate those with those glass. Those are the assets. So those are your bank accounts. Those are your retirement accounts. Those are your home. That's your LLC that you have. That's your artwork that you have. That's your collections that you have. All of those different types of things, and they can be customized as well. Okay, you have the opportunity to customize them. And really, what you're doing with a trust is you're taking your assets and you're placing them into that glass. And the reason that you do that is because you have an original trustee, which I'll explain on the next slide. And if you were to become incapacitated or pass away, you can hand that glass to the person that you named to be your successor right away, immediately. Okay. So every trust really has three different parties to them. They have the person or the people that set it up. All right. That's known as the grantor. A trust also has a trustee. That's the person or people that manage the trust and then follow the roadmap. When you set up a trust, it's a lengthy document of instructions, and it's really a roadmap for what is to be done with the assets. And then you have the beneficiaries. It's the people that are going to benefit from those assets. Only the trustee has the ability to manage the trust, and only the beneficiaries are able to benefit from the assets that are within the trust. While you're alive and you set up what's most commonly known as a living trust or a revocable trust, you're both parties. Okay. So you're the trustee and you're the beneficiary. So if things are done correctly, you're not feeling much of a difference within your own life. Okay. But if you were to become incapacitated, then you could name another trustee to take over managing those assets on your behalf. And if you were to pass away, you could then name new beneficiaries to then receive the assets. And all of this happens in a very seamless process of where things go. That's really how a trust operates. That's how it works when you're trying to have something. So I mentioned that you have to get those ice cubes into the glass. What does that mean? What types of assets are you coordinating? Well, you're doing things like real property. Okay. So that's your primary residence, or I have clients that have a rental property or a vacation home. It's different financial accounts that you have. It's your bank accounts, retirement accounts, investment accounts. It's life insurance that you have uh, as well, which can be really helpful for minors. As I mentioned, my wife and I have three children that are, 10, 8, and 3. And my wife is the beneficiary on my life insurance that I have. Um, and my kids ordinarily would be backups to that, but because they're minors, they can't actually inherit. If I had passed away, or if we had both passed away, my wife and I, a trust would need to be set up for the children, okay, until they became a certain age. Well, setting up a trust now, you setting one up, takes care of those types of situations, so can minimize the court involvements that's there as far as how everything is going to be taken care of, when it comes to life insurance proceeds or anything like that as well. And then you might also have, a business, so you can transfer ownership interest. And for individuals that have side hustles or their own small businesses or anything like that, this is really important, because if you have a situation where you need to operate your business and it's limited with who else can have access to that, if you pass away and that goes to probate, everything gets frozen. And then a lot of people are relying on you to make sure that everything is working, and it would not, but you would be stuck in probate, at the same time. You can then customize your trust as well. So as I mentioned, you can take care of customization for minor children, which means they can't inherit until a certain age, as well as adult children. You might have a situation where, you have kids that are in their 20s or grandkids that are in their 20s or early 30s, and you're thinking, I wouldn't want to leave them an inheritance all right away. I want to have that spread out over time. And a trust allows you to be able to do that. A percentage every 5 years or 10 years, or when they hit certain milestones, or if you incentivize it for certain things to occur. You can do that within a trust. You can also mitigate different types of taxes that you could be facing. While the estate tax is not something that's a real danger for most individuals, you can help with that. Okay. You can help with capital gains taxes as well. And as I mentioned earlier, estate planning is full of unintended consequences. So there's a lot of things that people just don't think of. And when somebody then receives an inheritance, all of a sudden they find out that there's all these taxes that are owed. And if it's just a home that's being passed down, too many times I've seen families have to sell a home that was intended to be kept just to pay off what the taxes and fees are that are involved. Trust can offer asset protection, like I said, as well, for the people that are going to be receiving an inheritance against divorces or creditors or different types of lawsuits. And you can have different standards that you can apply as well. You can make sure that you're taking care of family that has special needs, that you want to have focused on things for maybe their health or their education or their supporting them in different types of ways. So you have that opportunity with customization. And of course, there's lots of additional estate planning tools that go along with either a will or a trust. So, and again, I don't want to say that wills are not a good option, because if you work with someone like myself or another really qualified estate planning attorney, they can prepare a will to make probate a little bit less painless, but they can't eliminate it. A trust can eliminate it. Okay. But the other types of documents that you may be familiar with or have heard about are things like a general POA. That's people that are acting on your behalf from a financial perspective, if they're making financial decisions. There's a medical POA or a healthcare power of attorney, and it's people making medical, decisions on your behalf. There's a living will or an advance directive. These are these really tough decisions with how long you decide that you want to remain on life support for. And that's a document that really needs to coordinate with your healthcare power of attorney, because oftentimes people set these up on their own and they don't realize that they've put two different things in them and they conflict with one another, and there causes some issues about what are we supposed to follow. And of course, if somebody's trying to follow these, you're incapacitated, so you can't provide clarity. Estate planning also involves HIPAA disclosures, okay, to make sure that people can receive information on your behalf about your medical records or information. You can also set up things like I mentioned earlier, like that will plus kind of strategy, which is a beneficiary deed that you can try to strategically have your home bypass the probate process. It's just for your home. It's not for the other assets. There's no incapacitation protection, but it can at least move the home that way. And then there's TODs, or maybe some people have heard about them as just straight beneficiary designations, or PODs, pay on death, transfer on death. And you often see those with retirement accounts or life insurance, sometimes with investment accounts. Those are great. You want to make sure that they're up to date. But if you want to really make sure that you're taking care of your family, you should at least be aware of the fact that beneficiary designations have limitations to them, okay, as far as what they have to be able to do. And they're only one step away from the probate process. So I work with a lot of clients that set up a trust as a contingency plan behind different types of beneficiary designations. I know that this is a lot of information. And like I said, there's nothing that's really intuitive about all of this type of stuff. But I also mentioned that I kind of started my practice to be accessible and to be somebody that has an opportunity to explain these types of things to individuals. In addition to being an attorney, I have my master's degree in communication. I've done a lot of communication consulting, and I've taught at both University of Colorado and Metropolitan State University of Denver for several years on a variety of different types of communication and clarity classes and courses. And that's really what my aim is to be able to do. So if you work with me, you can kind of expect a bit of that hand holding to make sure that everybody has a good understanding of what we're doing. I'm not the type of lawyer that just says, let me get some information from you, then come to my office, then sign here. See you later. Okay. It's a process where we work together to make sure that I'm reflecting what you're trying to do for you and your family. So if you wanted to get started yourself on doing your own estate planning, I would say start having conversations with family and friends. You know, maybe they've worked with an estate lawyer before that they could recommend. Maybe they've gone through it. Maybe they're thinking about going through it as well. Maybe they can tell you about their own experiences. Nothing wrong with getting some feedback from people around you. I'd also recommend that you start writing out 3 different lists. And this ties back to what we had discussed earlier, as far as what estate planning is all about. Think about who do you want to have authority and name a couple of backups, because you might say, well, I want my spouse to have authority. Well, what happens if something happens to both of you at the same time? So think about who you want to have authority from a financial and a healthcare perspective. You want to think about what are your assets, do an inventory of them, and where do you want them to go? And then what are your wishes as far as how they transfer? Do you want to make things as easy as possible for your family? Okay. Do you want to, have some more structure around it so that there's more protection and space and inheritance out? What would you want to do? And then you sort of want to consider what your own approach is going to be. Do you want to hire an estate planner, sort of like myself? There's lots of options that you can go out there for to DIY, okay, to do it yourself. Um, a lot of lawyers will try to scare you off of that type of stuff. You've got to do what's right for you and your family. The one thing that I would say about DIY is, again, it's full of a lot of unintended consequences. I don't know if this is still the case, but I get a lot of clients that ask me to update or review their documents that they had done. They had ordered like a Susie Orman package, to put those together. And one of the things that I was able to see right away was, hey, so you know that you're filling something out and putting it together that is only valid under California law, which has very strict probate laws, because they're do-it-yourself forms and they have to pick a jurisdiction, and that's the one that they selected. So people are creating a Colorado estate plan, not being aware of the fact that it follows California law. And that's only one sentence within an entire estate plan that is, like a dozen documents or so. So if you're going to do DIY, make sure that you're really doing it yourself, that you're being aware of what's there. And then the last thing that you can do, as far as if you wanted to get started, is schedule a consultation with somebody, with an estate planning attorney or a firm. Like I said, maybe somebody. I'd love to be able to talk to the individuals that are on here if you have any questions. So like I said, after this presentation, I'll put my calendar link, where you can try to schedule some time with me. I typically meet with individuals for consultations or to answer questions a few days a week. So you'll be able to see that as well. And they're typically always over Zoom, an initial free conversation. And if we decide to work with each other, we can talk about if we're going to do it in person, if we're going to do it over Zoom, whatever it is. I try to be really flexible and accessible, like I had said. So thank you very much. Like I said, it's a lot of information. And when you can't see anybody kind of on this, it's hard to see if I'm either putting people to sleep, with this information, or if it seems like it's really helpful, at the same exact time. So I appreciate you guys being an audience for this. I want to open it up for any questions that anybody, might have in particular. If your questions are really specific about your own situation at all, if we're going to really get into the weeds about you and your mother-in-law and, what happens with a family heirloom, then probably best to schedule some time to talk with me specifically. But let me go ahead and share that here. if anybody wants to schedule any time, to be able to speak with me. And like I said, because you're part of the Colorado Coalition here, there's no charge for this consultation, nor would there ever be a charge for anybody that just wants to reach out and ask me some questions about a different type of thing. You're not going to get a bill because said to me, can you tell me again what the difference between a will and a trust is? I'm happy to be able to do it. So, does anybody have any you can either put them in the chat or unmute yourself, or I'll actually let the people that run this make a decision for how we'd facilitate questions.
I'm going to just say a quick thank you. I have to catch a phone call, Dave. You definitely didn't put anybody to sleep. Great
Okay.
information. But Carlin, I'm going to turn it over to you to manage questions and things.
Hi, Dave. That was wonderful. So if you have generic situation, a family member who has been admitted to the hospital suddenly, and the healthcare team says, hey, what are your plans? What are your thoughts? What recommendations do you have to people in the setting of serious illness and hospitalizations? And I'll read questions from the chat thereafter, or people can come off mute, whatever's best.
Great question. And I was going to say that with estate planning, as I mentioned, and you're thinking about from things for people to represent you from a healthcare perspective, there's really three documents that you're going to be focusing on. And I'm also going to share an additional document that you can create yourself now. Okay. Won't have any legal binding effect, but it can be able to be helpful to families. Those three documents are going to be a healthcare power of attorney that has to do with specifically people making healthcare decisions on your behalf. And you can customize that as to what types of decisions that you would want to um, have at all. You're going to want to have a living will. And again, that has to do with end of life decisions. So living wills are really exploring this idea of if you are on life support, if something were to happen and you are in a situation where doctors have said that this individual is not going to be coming back from this, and we are only we're keeping them on this uh, life support, artificial nutrition, feeding tubes, those types of things. If we were to withdraw those, they would pass away. Okay. They wouldn't be here. That's a really hard situation to have to think about, and it's a really stressful situation to think about. So an advance directive or a living will can help address those types of things before you go, if you were to go into the hospital or if something were to happen to you. As I mentioned earlier, you want to make sure that your healthcare directive or your healthcare power of attorney and your living will are coordinated together. Because on the one hand, a living will is you saying how long you want to remain on life support, and a healthcare power of attorney is you giving authority to somebody else, okay, to make those decisions. So which one controls? And a lot of times that's where things end up getting stuck, and that's where families start to get stressed out and argue with each other. You also want to make sure that you have a HIPAA authorization form prepared, because just because you have authority doesn't mean you get full access to information, and a HIPAA form would allow that to be able to happen. So those are the three documents. The fourth thing that I would recommend is this idea of creating a letter or some sort of something written for your family about what were to happen in that type of situation. So when I work with clients, I always say, look, I'm putting together legal documents for you that allow for the transfer of assets, but there's a whole lot of emotion that goes into this as well. If people are going to be making a decision on your behalf, I want you to be able to write some things down about what you want them to use as a guidepost for creating, what those types of decisions are, or arriving at what those are. What are your values? What do you want to have happen? What types of situations would you not want to be on life support? What types of situations would you want to be? How does your religious thoughts come into this? It's really powerful to be able to do that. And I work with clients to make sure that if they want to do that type of document, that type of letter, I'm able to assist them in being able to put something together and give some guidance for them as well. Does that answer your question, Carlin? Excellent. Good. Okay, Cynthia said, do you recommend just one representative or co-representatives if there are two children and you trust them equally, pros, cons of one versus two, and cost of creating a trust? Okay, so I never recommend having ever. People serving in that capacity together, co-personal representatives, co-trustees. Um, Not because you don't love your children, not because that they're not helpful individuals, but parents often conflate the fact that they're demonstrating the fact that they love their children equally by naming them both in this situation. Doesn't mean that you can't, and I have a lot of clients that don't take my advice and still go ahead and do that anyway. But if you name a co personal representative or a co successor trustee, you're creating unintended consequences for something as minimal as two signatures might be needed, and one of them is not close by, okay, and the other one is uh, close by and has the ability to, but you're slowing down a process because of logistical reasons. There could be a situation as well where what if they don't agree? Okay, if they don't agree with one another, then you're going to court. So a lot of if people say, well, is a trust going to go to court? It's not supposed to. But when it does, oftentimes it's when people have named co-individuals to kind of serve in that capacity. Doesn't mean that you can't. Again, you have that ability to. That's just my personal thoughts. What I recommend instead is you name one primary and one as the backup. Okay. So that way one has the authority and encourage them to talk with each other, but somebody has the ultimate decision-making capability. Also, uh, don't conflate the idea that naming personal representatives or successor trustees means that that has an impact on who's receiving what. It doesn't. Remember, there are trustees and there are beneficiaries. You can name them both as equal beneficiaries, okay? That they can each receive everything 50-50. I just typically recommend to people that you are naming individuals that are one primary and one backup, and sometimes more than one backup. That's a personal preference of mine based upon my experience of doing this, but it doesn't mean you can't. I have a client right now that she was like, look, my kids are wonderful kids, and I want them both to be able to do this, and they have to do it together. And one of them lives in the UK, and the other one lives in Boston. And I'm like, okay, I mean, uh, just want you to know, logistically it could hold stuff up, but if that's what they want, then that's okay. So that's just my own opinion. What is the uh, cost of creating a trust? It really varies, of course. Okay. You're probably not going to find a good quality trust that's going to be set up with somebody that's going to assist you with funding for something that's less than about $2,000. Okay. They can still cost upwards of, $8,000 to $10,000, depending on the type of asset protection and the things that you have involved, if you have special needs families and those types of things as well. Most people are not at that higher range. Most of them are closer to the lower range, but that's a range. Is there a generic HIPAA form? There might be. I'm not sure. So I was going to say that you can go on Google and see if there's one. I just don't know if it's legally compliant or not. I know that you have a kid that's going to be 18 soon. Congrats, in that. Oftentimes, what people are trying to do is not just the HIPAA form, however, but uh, you also want to make sure that you're taking care of the idea that you're looking at those other health related forms like powers of attorney, okay, at all. Um, what suggestions do I have for Spanish speaking colleagues in terms of estate planning? It's a great question as well. Uh, and this goes as a recommendation for anybody that is working with an estate planner to begin with. For me and for my experience in doing this, you want to work with somebody that you feel really comfortable with. So if you feel that a language barrier is going to be something that is difficult to be able to work with, you want to be able to find somebody in your Spanish speaking community to be able to work with specifically. The reason that I say this is because when I work with clients, I'm not just working with them when I prepare their documents for them. I'm then working with their families when something ends up happening, you know, to somebody, or if they want to make changes, or if they have questions. I also allow all of my clients to schedule a meeting with me even after we sign, you know, everything. We put everything together, where if they want to get on a call like this with their family members, okay, so that I can walk them through it or answer any questions as well. You know, obviously the client is a part of it too, but you want to make sure that you are working in a situation where you feel comfortable with the relationship, because the documents are important, but the relationship also really matters. Okay. What
Dave,
are, yeah.
Patricia has a question. She put her hand up.
Oh, sorry. Patricia, what's your question? And nice to meet you.
Sí, gracias igualmente. Voy a darles tiempo para que cambien el canal, ¿ok? Esta información es sumamente valiosa. Eh, Lamentablemente, tenemos contados con los dedos de la mano las reuniones o charlas que tenemos en nuestra comunidad latina en español sobre estos temas. Más allá de que hay una falta de experiencia, de educación en esto, es la falta culturalmente en nuestros países de hablar de estos temas, especialmente cuando los pacientes están en etapa 4 terminal, ¿no? Entonces es sumamente útil todo esto, y me preguntaba lo mismo que Carlin puso, si ustedes tienen una lista de abogados u otros especialistas como notarios, o quienes pueden hacerlo en español para llevar esto más a las áreas rurales, a nuestra comunidad latina en distintas áreas, acá en Colorado.
I don't have a list, but I'm happy to put one together for you. Okay, so I can do that, and I can share that with Ella and Carlin as well, so that you have access and availability to be able to speak with individuals. And that's a great question too about notaries, because it's important. The documents need to be notarized, and that just extends to the idea of the relationships are important. So if the idea is, yes, we agree the relationships are important, but we don't know who to talk to, then even if it's not myself, I'm happy to get some names over to them as well. Okay. And you know, that way you guys can you know, reach out to them to see if they're individuals you'd feel comfortable working with. Does that answer your question, or does that address kind of what you were saying?
Claro que sí, muchísimas gracias. Voy a hacer una segunda consulta, si me permites.
Yeah, of
Esto que
course.
acaban de hablar sobre HIPAA y las distintas diferencias y demás, creo que es sumamente de vuelta importante estos temas. Y me pregunto si puede haber una tercera sesión donde hables con más detalles, especialmente por las personas que están en cuidados paliativos o de vuelta muy graves, para hablar un poco en más detalles de estas partes donde ustedes sugieren todo este tipo de cosas.
Yeah, so yes. And one of the things that I had talked about with Carlin and Ella as well, when we had talked about doing these webinars or informational sessions, was, you know, starting off with some basic information about estate planning in general, but then maybe doing some additional ones if the community finds these helpful, that kind of address some more specific topics, kind of like the ones that you're describing. So if you all feel that this has been helpful and that's something that you would like, then I'm sure that Carlin and Ella will coordinate with me, you know, to be able to put something together that would be able to be to assist. I genuinely want to do whatever I can to be able to help this community out. As I said, it's something personal to myself as well, and has informed kind of how I've built my practice. So I think that's a great suggestion, and that's probably a really good topic for doing another one of these types of things as well, if we have the opportunity to. So that makes a lot of sense. Okay, Sherry had asked what are our thoughts about having a codicil to a will. So a codicil is like an amendment. I think amendments are perfectly fine. There's nothing wrong with them. It just depends on what it is that you are amending. If you are amending the fact that somebody's name was spelled wrong in the will, or if you're amending the fact that, your your children used to be minors, okay, and you had named guardians in the will, okay, that could be an entire topic of discussion, naming guardians, for people to take care of your children or grandchildren if something were to happen to you. Then, that's an easy change, and a codicil can make sense. If it's a significant change that you are trying to make because you're distributing your assets differently, or your wishes are completely different, or you were married and you're not married now, or you were not married and then you got married. If there's a significant difference, my recommendation would be to start over with something, okay? Not just have that codicil, kind of or an amendment. But that's a personal preference. It just, if it becomes really confusing as far as or if it becomes a big change, there's a greater likelihood that it can become confusing. And remember, a lot of times, these documents, especially a will, because it's intended for probate, is going to be read by lots of people and by judges and by individuals that are making decisions. Having amendments can sometimes unintentionally cause confusion. But if it's a light change, codicil works great. So when money is tight or limited, what do I recommend? That's a great question as well. There's a couple of things that I would say about that. One, you can probably, there are DIY types of options that you have the opportunity to take a look at. I don't typically recommend them, but I'm an estate lawyer, so it wouldn't necessarily make sense for me to, but I don't want to say that they're wrong. I mean, that they're terrible to be able to do. That just wouldn't be fair, at all. When I work with clients, I offer payment plans, okay, for individuals as well. And that's not very common that you see with different estate planners. And at the same time as well, perhaps if budget becomes a really big concern, then maybe the strategy isn't, okay, we're going to set up a trust. Maybe we're going to set up a will. It's less expensive to set up a will, and we're going to focus on minimizing probate as much as possible. But the thing that I want you to take into consideration is, yes, I understand that money can certainly be tight, but probate can be very expensive. So there's not too many things that I've seen as far as what you can spend initially versus what your family would be spending on the other side. And the fees that are spent on probate come from you. So they come from your estate. So as I mentioned earlier, average costs of probate can range between 3 and 5% of your total assets. And there's, like I said, if you have a $500,000 home at all, that's $15,000 to $25,000 in fees that have to be paid. If, versus kind of the cost of a trust, what I had described to take care of those types of things with it. But as far as setting something like this up, you have the ability to make payments over it. You can choose a strategy that is more in line with what your budget is going to be. You can try some DIY approach. There's a lot of things that you have the ability to be able to do. Uh, Donna, yeah, it's 2,000 to about 10,000. It's not, yeah, 2,000. So I was going to say not 8 to 10. It can cost upwards of that amount if people have different types of assets, or complicated family situations or those types of things. And I say that's the top of the range because sometimes that's what people have. Sometimes it's what people need to be able to do. But as I said earlier, most of the time it's much closer to that lower, range based upon what you're doing. What do I do in terms of recommending, in terms of communicating the documents in one home? Okay, so there's a few different types of things. People will have safes, they'll have safe deposit boxes. I try to do my part to assist individuals in two ways. One, I scan all of your documents for you, share them with you through a secure client portal so that I have them as well, because family members often contact me to say, I can't find my parents or family members' stuff. Can you take a look at, the different types of things that that I have. I also put all of my estate planning documents for individuals, and it's kind of a signature for me. I put them in an orange binder. It's bright orange. so that you can tell your family you need to look for the orange binder that you have. But clients show me their safes. They show me the different types of things that you have. They're all different types of, you know, options that people that they have as far as storing different types of things. So there's not one right or wrong way. Sometimes people keep it in their nightstand. But I always recommend to store it in some kind of a safe or safe deposit box. Try to do something that's fireproof, you know, certainly, and have comfort knowing that you have access to digital copies as well, which most of them are accepted as valid at the same exact time as well. What do I recommend about digital affairs? Online banking accounts, social media accounts, all of those types of things as well. A few different types of things. Trust and estate planning address those in your trust to begin with, so they're become part of it as well. There's things that you can do with your social media accounts that have settings as far as legacy, you know, what you do from a legacy perspective as far as who can access. And you can set that up almost like a beneficiary designation now. With online banking, you're talking about an asset, okay? A bank account that you have, you're going to want to fund that into your trust. You're going to think of that as an ice cube that you want to be able to get into there. So like I was saying, you want to make sure that if you're setting up a trust, whether you're doing it DIY or with someone like myself, that you are doing it in a way to address those types of things that you're asking about specifically, because that's part of estate planning. Hopefully that answered your guys. Any other questions in the minute or so we have left?
I'm trying to type, but I guess I'll talk faster.
Okay.
If somebody passes away,
Mhm.
what do you recommend the family members, the survivors do if there is no document? Is it best to contact an estate attorney first, or let's say the planning isn't done?
If people don't have anything at all, what they'll find out pretty quickly is when they try to access the accounts that they don't have the ability to. Okay, that unless they're owned jointly or unless there's a beneficiary designation for them, but they'll typically start by going to the bank or contacting a mortgage company and finding out that the person won't talk to them, just like Carlin, I can't call your bank and have them talk to me now, you know, at all. What the bank needs is, or the mortgage company or any of those things, they need is authority. Okay. They need to show that you have the authority. And as I mentioned, estate planning is full of three things: authority, where assets are going to go, and how it's going to get there. So naming authority is really important. If no one has authorization and people think, well, of course it'll be me, I'm their child. It's not the case. Okay. It goes to court. So in order to get authority, everything gets frozen, and the probate process, the end of the probate process, is what gives the all clear for you to have that authority and to make sure that it is past the statutory time period for creditors to then move the assets. So a trust allows it to happen right away, and a will makes you wait through that entire process. The court has to be able to look at it. So if you don't have any planning done, it's longer. Okay, it's longer, it's more expensive. If you do have a will in place, it can minimize it, it can mitigate it. And if you have a trust in place, it can bypass it.